calling the folks who were shot by Rittenhouse victims. He said that himself. He held up a stack of hate mail, and he said most of it had to do with that particular ruling. But to be honest with you, Philip, I don't necessarily have a problem with. We talked a little bit about it before. It's worked in the system for years, but if the system can be better, I'm all for it. And he made a good argument for that particular thing. I want to know what you think about it.
The word victim preconditions juries pre-verdict into thinking that the defendant has committed a crime. Ultimately, the legal definition of victim is a person against whom a crime has been committed. And it's one thing to say that a defendant is accused of a crime, charged with a crime. It's another thing to call the complaining witness or a decedent a victim of a crime because it has not been fully adjudicated yet. So I think this judge was very astute. Now, if a defendant is convicted, then for purposes of sentencing, the prosecution has met its burden, and now you can have victim impact statements at sentencing, and certainly you can have a restitution hearing where the victim, the victim's family, the derivative victims can come forward and seek compensation for any economic losses. But prior to that determination, he is presumed innocent, and as far as I'm concerned, the proceeding should remain victimless.
You know, and it's interesting because, that's to me, it's enlightened thinking. I hadn't thought of it. And, we've seen it more often now in trials across the country that we cover here on CourtTV. That same issue comes up and judges have ruled the same way. So, I'm all for it. Again, as I said, if it's an improvement in the system, makes for fairer trials, I'm all for it. And finally, I want to discuss with you this idea about the video. That drone video, when it was being presented to the court for introduction as an exhibit, the judge didn't really understand a lot of the technical lingo. He was having a hard time understanding about whether you can alter a video by expanding it, pixels, and all the other things. And I'm wondering if you think not only lawyers, but judges as well, have an obligation to stay up on these developments, because video is such a big part of trials these days.
Well, let's be honest, Michael. A lot of the old folks, and, quite frankly, I'm going to be 62 this year, and I'm kind of a low tech. We need some schooling and training on this stuff. None of this stuff is self-authenticating, and sometimes lawyers, judges, and even jurors, they have to be schooled and educated, and a foundation has to be laid for this digital type of evidence. I don't see a problem with it. In fact, it's probably better that you lay the foundation for it rather than a judge apply his own personal knowledge and sit as a trier of fact as opposed to a referee. You let the jury decide the legitimacy and the validity of the video itself. But if a judge, for foundational purposes and authentication purposes, needs some guidance to determine what, if anything, is being depicted, then I think it is incumbent upon counsel to lay that foundation and to authenticate it for the court. That's exactly what they're there for, is to get it all authenticated, the foundation laid before it goes to the jury.
All right, Philip Dube, always appreciate your insights. And by the way, you look great for 62. I just have to say that. All right, stand by. We're going to take a break. When we return, we have our daily talkback segment.